Viewers, welcome to the Personal Injury Law Show. This show that talks about everything current in the law of personal injuries and obviously of importance to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer with 30 years experience. With me today I've got Don Maffia, partner in the law firm in transport accidents. Good evening, Don.
Good evening, Tony. Good evening, viewers.
And Aki Munir, a senior lawyer in transport accidents in the law firm. Good evening, Aki.
Good evening, Tony. Good evening, viewers.
Viewers, tonight we're going to give you an update on transport accidents and road users.
But of course, Tony, before we get into that, what's in the news?
Well, Don, one of the things I want to discuss before we get to specific matters is I'm astounded at law and order in this state of Victoria. Recently, we've had gangs attacking people randomly in the city. Yesterday, we had a case of a young lady getting kidnapped in a car park, sexually assaulted, and then they locked her up in her own boot. Where's this country going, Don?
Yeah, look, it's a scary thought, Tony. I mean, every day, and even shootings every day sort of happening. Look, Tony, it is definitely a hot topic at the moment, law and order. All the political parties now looking at it, and everyone's top of their list as to what they want to see happen. More police presence, more control, dealing with these crimes, activities, and the increase in criminal activity. So I'm astounded by it, and something has to be done by it, Tony.
Aki, I think it's time now for the judiciary to make an example of these people. It's no longer a case of they get to court, they argue mitigating circumstances. Oh, my client was on drugs or broken home or things like that. Look, it's not that I don't feel sorry for these people. It's just that if you don't set an example, things just keep getting out of hand.
Well, that's right. I also think that, the streets have been quiet for a while, and now all of these crimes occurring, we've got to be more proactive rather than reactive in our response.
But Tony, look, the problem is though, it's too late when they get to the court system. We should prevent it
that's
from
a good
before.
point. I do like that.
Because then we look at, obviously the court system are clogged up with a lot of cases, and being the civil litigators that we are, we know that a lot of the judges' times are taken up by the criminal.
Crime makes up 90% of matters.
And secondly, of course, there's also the problem with once they get imprisoned, the jails. There's just not enough facilities to deal with this influx of criminals. So it's getting before them to get there. It's prevention to get there. We need something done differently by political parties. More funding, more police presence, and the like.
Exactly. And by the way, viewers, Don just mentioned an important point. When you're complaining to us lawyers and everyone else that your case can never get to court, the very valid point Don made is that about 90% of all cases in these courts are criminal matters, and they do clutter up the system and take up most of the resources.
Right, they do.
Anyway, let's keep moving. Commonwealth Bank employee gets dismissed and he leaves work because of a depressive condition, and a former CEO of the bank said to him that he should retire because of his depression.
Yes.
Then when he lodges his superannuation claim, TPD, with ComInsure, what happens, Don?
They say no.
That's
so
bizarre,
his insurance is obviously underwritten as a Commonwealth Bank ComInsure. So he's been sacked from his employment, and then because of his injuries, or in this case was depression, then makes a claim with his own insurance that he took out, obviously through superannuation, which is ComInsure, and they turned around and said, well, no, you're not entitled to it because you have capacity to work.
Yes.
So very contradictory on behalf of Commonwealth Bank. On one hand, they say, we're going to let you go because you have no capacity. And then when he makes an insurance claim, they say you have a capacity to work.
Exactly.
It's
and
bizarre.
Aki, ComInsure is under fire at the moment because they've been making some very, very weird decisions, and they've been putting these poor injured people through the hoops. I mean, this is not the way to treat people, is it?
Oh, yeah. People are waiting years for a payout, and, these are people that aren't able to work. They don't really have an income, and they're really struggling. So a lot of people just give up on the system. The other interesting thing with this case, Tony, is that they've relied on the same report that they used to, terminate his employment, saying that he's got no capacity for work, to say that actually, no, he does have a capacity, and therefore they're not going to pay out his insurance.
And look, there's insurance people out there should realise that these poor people, financial destitution and destruction of families. That's the real tragedy today, I think.
You think it's insurance, you pay your premium, so you should be entitled to it. It's not as easy as that. So definitely you need to seek legal advice when you're dealing with these type of claims.
Exactly.
Because there are different tiers of tests that apply to these type of insurance, and you can see, like Commonwealth Bank, can make it very difficult for people.
Exactly. A Commonwealth employee, Don, Anastasius Zoumas, had an injury to his neck, significant disc problem. He tries yoga to try and help his condition, and it gets rejected. Why?
because it's not regarded as, well, there wasn't enough medical evidence to support the benefits of having the yoga. It's the Bikram yoga, Tony, so I think you go in those hot rooms and do the yoga type of thing. But interesting about this case is how he injured his neck. He injured his neck because he was on a plane, a long-haul plane, so he's a Commonwealth employee, and he slept in an awkward position and sustained a neck injury.
That can happen, I mean, and plus you don't have to prove fault when you're claiming medical expenses.
Correct.
Aki, he was trying to help the employer here because he said that the yoga exercise he was doing was reducing the amount of treatments he had to get.
Yeah, that's correct. I mean, Bikram yoga is actually really good. I've tried it
Oh,
myself,
so
you know
I must
how-
say. So, look, it is good, but it's not medically proven.
Why would they reject it? I mean, if he's not going to spend money on other things, wasn't it going to be a saving to the employer?
Well, it makes sense to accept it. What they do is they just follow their policies, which aren't always correct and not always logical. But of course, policy isn't the law. For example, with the Transport Accident Act, they've got the policy which they do follow, but decisions like that can be disputed.
But I think Taylor just trying to draw a line. So where does it stop? From the insurance side, they'll probably say, well, look, now it's Bikram, and then we could look at other things like Reiki and all these things which are not
but
yet.
they were going to
it's not
save money on
medically
other
basic.
treatments, though.
Yeah,
Anyway.
I just think he's trying to draw a line, and sometimes they get it wrong.
We'll come
That's
back
why
to
it
it
goes
when we do a
courts.
CompCare episode, I think.
Correct.
Terrorists turn back, Aki. Some refugees refused entry here due to ISIS fear.
On what basis are you suspecting that they're terrorists? So apparently there's security checks. I don't actually know. what's
Background
involved.
checks.
But to what extent when you're trying to get information from another country, and particularly a war-torn country, how much information can you really retrieve?
Don, I'm really impressed with the current immigration minister, federal, where he's sending people back to the countries they're from and getting rid of their residency when they've committed crimes or if they're people with bad repute.
Yeah, and look, and that's a good thing. I mean, we're in a world now where there is terrorism, a threat every day. But again, in these circumstances, Tony, it's a very fine line, because being from a country, being a true refugee doesn't necessarily mean you are going to be a terrorist.
No, but there's got to be
there's gotta
some
be-
sort of
it's such
safety checks for us too.
Yeah, of course. Oh, most definite. And look, it's a shame, because we are in this world where terrorism is such a threat and we live in fear.
It's just outrageous anyway. Driver dragged under a bus, Aki. What happened there?
The driver in this case was actually working underneath the bus. And it seems like something had failed, and the bus dragged him
rolling.
about 200 metres. So it's a long way to be dragged under a
Jeez,
bus.
Johnny's lucky to be alive, isn't he?
Oh, look, he is. And that obviously work safer in there investigating, because the workplace it's a dangerous, being under a bus and it rolls over you like that, it's a dangerous employment. So they have to be very careful about these situations. And Tony, this guy's obviously entitled to work cover claim. We are talking about TAC.
There's an overlap with TAC as well.
Correct. And look,
Yeah.
if it wasn't working, he was just doing his own work under the bus, he will be entitled to, under the Transport Accident Act, for benefits, because out of control vehicles fall within the scheme of TAC.
Okay. Well, at least he's covered. That's the important thing.
Correct.
And fortunately, he's alive. Anyway, viewers, we've got to go to a sponsors break. Stay tuned after the break. We'll give you an update on TAC cases. Viewers, welcome back to the show. We're going to give you an update on transport accidents. The first case we're going to do is in the papers and actually before the court, so we probably, I don't know if we should mention the name, but maybe not. We've got a motorist who's suing for negligence after he was injured outside Westfield, Doncaster 20 years ago, and Aki and Don got an extension of time after so many years.
That's right.
Don, tell us a bit more about the facts of this case.
Well, the fact is she's the plaintiff in this case, called Plaintiff Defendant.
Yeah, don't
Plaintiff
mention- probably
was
don't
involved
mention
in an
names,
accident
yes, yeah.
20 years ago, made a claim in Victoria under the Transport Accident Act, so Transport Accident Claim, and tried to bring a claim for damages 20 years afterwards. And the purpose of this case is the case is subject to many different stages of litigation. But in Victoria, you only get 6 years, Tony, from the date of the accident to bring a claim for common law. She's trying to bring it outside that, so she needs an extension of time, so leave from the court.
Okay.
And that's what this case was about.
Well, Aki, in this case here, she went to court, and the first thing the judge had to decide is, can she sue outside the time limit, which we know as Section 23A of the Limitation of Actions Act 1958, as amended.
That's right, Tony. Well, the plaintiff required leave of the court in order to actually claim compensation in this case because she was so far out of time. Time expired in 2001. She's bringing a claim, I think it first started in about 2007.
Yes.
Well, the court has to decide whether or not it's just and reasonable to bring a claim in these circumstances.
Well, Don, one of the key elements in this case is her own state of knowledge.
Correct.
If she's aware of the law,
Yeah.
that's it.
We should say to viewers, Tony, that out-of-time application or an out-of-time claim is an actual defence to your claim. So you
Yes,
may have a
of
great
course.
claim.
Yes.
No issue. Like this case was no issue of who's at fault.
Yes.
It's really just a question of damages.
Well, Don, just on that point, that's probably why the judge gave the extension.
Yeah.
Because one of the issues raised by the Transport Access Commission was they were prejudiced.
Yeah.
And the prejudice issue they raised was the treating GP was died.
Yes.
But the thing is, because in this case here it was a rear-end collision, there was no issue about liability.
That's right. And,
So,
and there's been plenty of annotations, doctors' reports and all that, so they really didn't need the GP then. That was the whole point. We could have done it all on paper. She's got a new GP who's well-versed about all her claim and
Yes,
all those things.
yes.
So that's where ultimately the prejudice, although TAC, the defendant would have argued it was prejudice, the judge said, well, that's not enough. You've got the information there.
Well, Aki, this plaintiff was never going to be in the lurch because her original lawyer, right, was an accredited TAC specialist who apparently, according to her, didn't advise her of her rights to pursue a claim within 6 years. And so if she had failed in her extension application, in all probability, her next claim would have been suing the lawyer for failing to advise her of her statute of limitations, 6 years to sue,
That's
correct?
right. Anyone practicing personal injury law is well aware of that 6 year time limit. So you'd be surprised if the lawyer didn't advise her on the 6 year statute of limitation period.
Well, Dom, why wouldn't she get an advice letter saying, dear Mr. So-and-so or Miss So-and-so, please note that your claim, you got 6 years from this date within which to pursue a claim.
Yeah.
It's very rare.
The lawyer was never called to give evidence in this case, and probably rightly so.
Isn't it
She's-
suspicious?
Well, look, her file was destroyed. In Victoria, only required to keep a file for 7 years, and then it'll just be he said, she said scenario. Like
So they
was
didn't
told,
call him
wasn't
for
told,
that
so
reason.
we don't know. But with the courts, Tony, they do look at not only whether there's any prejudice, but they also look at a number of things, criteria as to whether or not to grant extension. Obviously, the length of time.
Yes.
They look at things such as what did the plaintiff do to protect her own interests.
Yes.
So if she just sat on her hands and the plaintiff did nothing about it, that may not be enough to get you an extension of time.
Well, I'll tell you what, she's fortunate that she hasn't had previous claims because when the court looks at your own knowledge of the law, if you had previous claims, they could infer that you knew there was time limits. And you probably don't even know it's 6 years. And that might be enough to knock you out, correct?
That's right. I think any person who's sought some sort of legal advice or has gone through this process before, there would be an assumption that they are aware of the time limits regardless of whether or not they've actually been advised.
Don, many years ago, a good friend of mine, GP, was involved in a car accident where he got a neck injury, okay? Now, he did a lot of these claims over the years and he did not attempt to lodge a claim for medical treatment until 12 months after his accident.
Yes.
TAC rejected his application. We went to VCAT and believe it or not, he failed. He needed neck surgery eventually, but he failed because the court said that being a medical practitioner who's handling these sorts of cases, it's reasonable to assume that he wouldn't know there was time limits. I find that
sounds
extraordinary.
hard.
Yeah, she lost.
Well, this way she actually worked in the law office too.
Oh, she got lucky then.
But of course, it wasn't in the law of torts.
Yeah.
Yeah, she had a prior work cover claim too. So,
Oh, look, she's very
that's
lucky,
not
I
a very
reckon.
harsh decision.
Well,
but-
the judge found against the doctor based on the fact that he was a person that's specialised in car accidents and should have known that there was time limits, and they didn't grant the extension.
And that's the thing, Joe. We shouldn't take for granted that if it is out of time, you will get an extension
No,
of time.
no.
So it's quite important when you go have an accident, seek legal advice, but also ask the question, what are my time limitations?
Exactly.
Because if, like we said in this case, all right, there was no prejudice, but if there was an issue as to who was at fault, and let's say defendant's missing or passed away, and it would be very difficult to get that extension of time.
Yes, yes. Well, if there was an issue of liability here, I think she would have failed. Correct?
Yeah, that's right. Witnesses die, witnesses forget, so
Exactly.
it's very difficult to obtain the evidence 20 years after the fact. So.
Exactly.
Yeah.
And plus also, one of the things working for her here, and I know the judge that gave her the extension knew, was the fact that she had a fallback position, didn't she?
Yeah.
She did have a fallback position.
Potentially she did.
Yeah,
And the thing
yeah.
is, when she did seek instruction, it was after the time expired, she did go to another lawyer, and straight away they started acting on her instructions to protect her interest.
Yes.
So that obviously does help as well. But yeah, look, Tony, like I said, just cannot take for granted. So definitely, if you have an accident, go seek legal advice and get those advice about timelines.
And on that point, they should ring you at Wiki Carbone on 1300 Injured.
Yep, that's right. Go to the Wiki Carbone, go to
And
our
if they
website.
can't get you,
1300.
get the bulldog. Aki. The other thing about this case, just quickly, it's currently before the court, so we've got to be careful we can't say too much. But I'd imagine that they've had a mediation, there'd be offers of compromise, and Don, an offer of compromise is very important, isn't it?
Oh, look, it is. So that's where you pretty much draw the line, and you say to the other party that if we get more equal to this offer, and if if you don't get it more equal to the offer, then you'll have to pay pretty much the other party's costs. There's penalties applied to it, and the costs are very significant.
And Aki, if you're a plaintiff and they make an offer of compromise to you, that's the insurance company, and you get under that offer of compromise, you are truly buggered, aren't you? Stuffed.
Exactly right. It's almost a loss. Regardless
it
of
is a
any
loss.
compensation, it's a
I mean,
loss.
Supreme Court,
so-
there's no change out of $30,000 a day, surely.
Yeah.
No.
Look, Tony, that's it. If plaintiff puts an offer of compromise and gets better than an offer of compromise, then the defendant has to pay costs at a higher scale. And
Well,
if
but
you
it's still
reverse,
shortfalls. There's shortfalls.
of course,
Yeah.
we'll call indemnity costs.
Yep.
If it's the defendant that puts an offer of compromise, plaintiff goes under, then the plaintiff will have to pay the cost from the date of the offer.
My view is if you're not that far away from the offer of compromise in terms of what you want, just take it to avoid any risk. On that note, viewers, stay tuned. We're going to a sponsors break. We'll be back with more cases after the break. Viewers, welcome back to the show. We've got a case of Maffia and Transport Accident Commission, 2015 decision of the Victorian Supreme Court of Appeal. Aki, this case raises a lot of interesting issues. It's very important that clients are consistent. It's very important you get your facts right at the start. If you try and change them during the course of a trial, it creates serious issues about your veracity and credibility, correct?
That's right, Tony. We'll start off with the facts of this case. We've got the plaintiff, Mr. Maffia. He's driving back to the work site. He alleges that another car sideswiped him, causing him to lose control of his vehicle.
That's important. Sideswipe.
Correct.
Okay. Yep.
Correct. Causing him to lose control of his vehicle and collide with an oncoming truck.
Yes. Don, what happens at the trial?
He loses. So that's
Why?
it.
Why?
So-
Why did he lose?
Well, the judge did accept it. There's
All
a
right.
couple of things
Yeah.
about it. One was whether or not he was sideswiped or hit from behind by
All right, let's
an
stop
unidentified vehicle.
There was an expert engaged who did a reconstruction, correct?
Correct.
Dr. Axett or Mr.
David Axett?
Yep,
Yes,
yep.
yes,
What did
yes.
he say?
Now, he said that there was a didn't car was not caused by a sideswipe, so that's quite significant. But
How can you be so
consistent with
sure?
Two vehicles making contact. I guess
On a
that's his
balance of
job, isn't it?
probabilities.
Balance of
correct?
probabilities.
Yes, yeah. Okay.
So there's a couple of things, but there's a witness. One was an unidentified vehicle. So he said it was hit,
Yes.
drove off, and caused him to lose control and hit oncoming vehicle. There's two witnesses, including the oncoming vehicle they had a head-on collision with, saying we did not see any other vehicle in the vicinity prior to the accident, and just said he came out, was out of a roundabout, and lost control onto an oncoming vehicle. The passenger in the car of the plaintiff has no recollection of the accident at all.
Which
So
is
it's just
pretty
no
damn-
evidence.
That's pretty damning.
It is. So it's really just his
Yeah.
evidence. So on that basis, the judge didn't accept it.
Anyway, Aki, Getting back to AXIP gives this report that says that he doesn't believe the car was sideswiped. So what does a plaintiff do then?
Well, the report given basically says that it wasn't sideswiped, but it could have been contacted by another vehicle. So the plaintiff decides to change his pleadings.
All right, he wants to amend his pleadings. Statement of claim.
Correct.
What's a statement of claim?
Well, your statement of claim is your pleadings. It sets out the basis of your claim.
So pleadings, Aki, to break it down for the viewers, is you set out the grounds of what you say is the reason why the defendant is at fault, correct?
Your allegations of negligence.
Yeah. And Don, your standard pleadings, careless, failing to keep a lookout.
Too fast in circumstances.
Yes.
Not having proper control. So
And
that is standard. In each case, it's different.
And lawyers use the shotgun approach more often than not because
Put it
things
over here.
things come up during the trial, correct?
Correct.
Yeah. And you can rely on more than one reason to get a defendant found guilty of negligence. That is, going too fast or not keeping a proper lookout or failing to indicate. There's a whole host of things, correct? Anyway, there was another important consideration in this case, Don. And when it got to the Court of Appeal, it was heavily contested.
Yes.
The issue of credibility was taken up because there was a previous allegation of rape and a rape case where he was found not guilty. He was acquitted.
That's right, and that was a whole issue. Such evidence can be so prejudicial in these type of cases because ultimately, and where we're talking about a story that he says happened and there's no one else to verify that story, it does come down to his credibility. So all of a sudden there's some evidence that was not produced, Tony, as to his credibility to say that, he was previously charged with rape, there's someone towards about this. It actually went to his mental condition, which he alleges was affected by the accident.
Yes.
So the way that came in is because when he was examined by his own doctors plus independent doctors for the purpose of the case, psychiatrists, of course, the mental status of the plaintiff before the accident
was already impacted by
Correct.
the case that he'd had to defend.
Correct.
Yes.
So the evidence, such evidence of rape and that was not introduced for his credibility, it was introduced to determine the extent of his injuries.
Yes.
And that was very highly contested, as I said, because it can be very prejudicial.
Yes.
Very prejudicial going before a jury. Ultimately, the judge allowed it, but gave very stern direction as to that type of evidence.
Okay.
And even in this case, the defendant did not take much issue with, did not really cross-examine on those issues.
Well, the defendant didn't want to cross-examine really for the simple fact that the plaintiff's case had gone so poorly in relation to negligence anyway.
That's right.
Why give the plaintiff grounds for a mistrial?
Well, that's it. But the other thing too, Tony, is that there is such evidence cannot be introduced for issues of his credibility.
Yep.
And that's why it's very limited in what you can use it.
Okay.
But once it gets out there, it's out there.
Aki, so the judge had to weigh up the probative value of the evidence as against the prejudice it might place on the plaintiff's case. Weighing that up, the Court of Appeal then turned around and said it shouldn't have been allowed, correct?
Well, that's right. At the end, what happened is this report in particular that the doctors were examined on, it was found that the pre-existing allegations of rape did not affect his current mental status.
And in those circumstances, the prejudicial nature of the evidence outweighed the probative value to the court.
Correct. It wasn't relevant.
But it was a hollow victory anyway, wasn't it?
That's right.
Because he lost his case.
Exactly.
So, Dom, you won that little bit of a battle, but then you lost the war.
Yeah, and look, that's these cases, Tony, a lot of it turns on the evidence that's introduced, and particularly when you're talking about he said, she said, well, in this case, just what he said, and it really goes down to an assessment of whether or not he's telling the truth.
Well, Don, just on that point, viewers, what's critical and absolutely of utmost significance in these claims, you cannot diverge in your story. You've got to be consistent. The minute you start saying, I slipped as opposed to I tripped, or I tripped as opposed to slipping, or I got sideswiped, in fact I was touched, no one's going to believe you. And especially when you've got other factors in the background, like you've got criminal matters in the background that come out in the evidence. In this case, the previous case of rape where he got acquitted. I mean, the jury's going to play in their mind, they're going to think, I'm not sure if we're going to go for this bloke.
Yeah.
You know what I mean? So that's pretty important.
Tony, there are the evidence rules which are very strict in terms of how this evidence gets introduced before the jury.
Yep.
And this is just one example. It wasn't used for his credibility, but it was definitely used for his mental condition at the time of the accident and how it's affected. But it's affected his case.
So viewers, your integrity is absolute utmost if you're going to win these claims. All right, let's quickly do the matter of Valevsky and Zoo. No, Victorian Supreme Court case 2015. We don't have a lot of time, Don, so give me the facts quickly.
Self-represented plaintiff crossing a road, there's a four-lane carriageway, gets to the second lane and gets hit by Mrs. Zoo.
Okay. Serious issues about speed. You know, how fast was the defendant going? He was trying to say she was doing 60. She's trying to say she was doing 40. It was one of those 40 zones because of school hours. Anyway, the call to the ambulance really fixed him, didn't it?
Exactly. So they had the time of the call to the ambulance from the witnesses, as well as having two witnesses themselves. So that really clarified the facts.
So instead of accident before 9:30, it happened after 9:30.
Correct.
It's very significant in terms of speed, wasn't it?
Correct.
Yep.
And look, Tony, the thing is, there was a witness to this case. There was a couple of witnesses.
Two
One
witnesses.
of the witnesses who was driving his car in the left-hand lane, so closest to the curb, sees Mr. Valevsky, sees him not looking, so decides to...
And there was an issue about whether he was walking or running.
Correct. So
Yes.
he decides to not brake but slow down, and that's when Mrs. Zhu, who's in the second lane, close to median, he says coming up from behind and could
Yeah.
see that she was going too fast and didn't see Mr. Valevsky crossing the road.
Yeah.
I think it's a harsh judgment, but ultimately the judge weighed up the evidence. I think if you have a car in front of you in the left-hand lane slowing down, the driver in the right-hand lane should become aware that there is a danger coming up front.
Don,
But
even though Mr. Valevsky wasn't totally truthful, right? Because I mean, all the documented evidence was against him. The fact of the matter is, I agree with you that there should have been apportionment of blame. He probably should have been 70-30 against him.
yeah,
Or even 50.
he said it was jogging and all that, but
Yeah.
I think if you have a car in front of you that's slowed down, there's no reason to slow down. You should be aware something's going on.
Yes, yes. All right, on that note, we'll come to the end of the show. Aki, thanks for coming on board.
Thank
Don,
you, Tim.
thank you for coming on board as
Thanks,
usual.
Tony. Thank you.
Viewers, thanks for watching. Stay tuned for future episodes. Go to our past episodes on YouTube. Go to our social media platforms. And always remember to stay safe.